Good morning. This is Pat O'Connell. I'm calling to order the regular open meeting of the New Mexico Public Regulation Commission. It's Thursday, August 13th at 10 a.m. We're at the New Mexico State Capitol in room 322. Please call the roll.
Commissioner Nybert?
Present.
Commissioner O'Connell?
Present.
Commissioner Aguilera?
Present.
All commissioners are here and you have a quorum, Mr. Chair.
Thank you. So next we'll rise and do the Pledge of Allegiance and the State Pledge. Get our virtual flags up here. Oh, the virtual flag flyer is not here, so imagine. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico as the symbol of perfect friendship among united cultures. Thank you. Gentlemen, we've got an agenda that was posted on Monday in front of us. Do you see any changes you need to make to the agenda? Seeing none, we will proceed with the agenda as posted. Announcements. Try to use this space just to announce things that are upcoming between now and the next commission regular open meeting, and there aren't very many things scheduled. There's a one-day hearing scheduled for the 18th, which is a request by El Paso Electric to reinvest in the Eddy tie, a HVDC connection between El Paso's system and SPS's system, which is really a connection between West and the Eastern interchange. So that's scheduled for the 18th. We'll see if that happens. And then there's also currently scheduled a hearing on PNM application for CCN and right-of-way on a transmission project. That's case number 2641, Wednesday, August 26th, start at 9 a.m. And again, that's scheduled for a one-day hearing. And then we'll have our next regular open meeting of the Public Regulation Commission on August 27th. As those of you who are here today know, we've been moving around a little bit. Generally, we're in the State Capitol building somewhere. So if you look at the agenda, we'll have a room posted on that agenda. I think we'll be back in the through 307, 309 neighborhood in 2 weeks, but not sure. So anyway, we're here today and glad you found us. Are there any other announcements? Nope. Next up is public comment, and we have one gentleman registered for public comment, Jose Villegas, better known as Chappie. We're broadcasting this meeting on live stream via YouTube. So if you could approach the mic and push the button circled in red to make it green so the internet can hear you, and the floor is yours.
Oh, there's a green button. Okay, got it. Buenos días de Dios. Amandi Botene Bonewe. And good morning, commissioners. My name is Chappie Jose Lorenzo Villegas Sr. I'm addressing you on behalf of the La Valle de la Cieneguilla Land Grant Association and the Texas Band of Yaqui Indians as someone affected by the recent PNM power outages in June and July of this year. My tribal and indigenous community, as well as so many others, experienced firsthand the life-threatening risk of public safety, health, and welfare of our community. Elderly and children alike have lost food, face health and medical conditions risk because of a lack of power, and were left sweltering in the adverse heat and unpredictable weather conditions. I'm here to request the Public Regulation Commission to seriously consider the increasing life-threatening risk of public safety, health, and welfare of our tribal and indigenous community of not having any recourse in the face of PNM and make a just and ethical and regulatory move to abolish, amend, or modify second revised P&M Rule number 12 that was approved and replaced by the Public Regulation Commission on March 7, 2025, in accordance with Rule number 17.1.210. This request is only to protect the best interests of people like me, my family, my neighbors, my community members who have a way to hold P&M accountable for these unnecessary power outages. P&M Rule 12 leaves us completely disempowered before a public utility that can make decisions that may not be ethical or fair to our community. What would it take to change this rule so it protects our safety and improves our quality of life? Must someone with a medical condition die during an unnecessary power outage before the Public Regulation Commission recognizes this imbalance of power? P&M's continued failure to upgrade its inadequate electrical infrastructure under the guise of a deferred maintenance puts the public at risk and may expose the company to punitive damages under a tort claim. In conclusion, the 16 significant P&M power outages that have occurred in La Cienega land grant on Pueblo lands do not meet the P&M Rule 12, Section B criteria, where it states other circumstances beyond the control of the company. In such case, the company will not be liable for damages. That's a heartbreaker. Therefore, it is my strongest opinion the existing poorly and dysfunctional maintained generation, transmission, or distribution facilities of the company fit right into the deferred maintenance scenario of a failed infrastructure and are totally under the control of the company's responsibility and accountability to operate in accordance with the PRC jurisdictional matters. It is time for the PRC, brothers, to hold P&M accountable for failing to provide adequate preventive maintenance, timely part replacements, and necessary repairs to preserve the reliability and functionality of its electrical infrastructure. My indigenous tribal community shall no longer be sidelined by the public service company of New Mexico leadership. We need your regulatory authority. We need your support and subject matter expertise to reconsider P&M Rule 12 and abolish, amend, or modify it under your current authority. I suggest an amended rule to compensate accounts that suffer outages for more than 4 hours. Compensation could be set at $500 per day and per event to cover the cost of generator rental and replacing spoiled food in cases where outages is caused by deferred maintenance or poorly executed infrastructure upgrade projects. These are just some suggestions. I would love to work with your staff and come out with some good, positive outcomes for our community that's being impacted by a corporation called P&M. I'm willing to work with the community at large. As a chaplain, law enforcement chaplain, I respond to death almost daily across the state of New Mexico. I don't want to have to go to a call just because a 7-year-old little boy who was on a life support system in my community didn't have electrical power because the P&M failed to keep their stuff up. I appreciate your time, your efforts. Blessings to each one of you and your families, and I hope that we can talk some more. Thank you, sir.
Yeah, thank you very much for your comment. Just for awareness, the gateway to our staff is our chief of staff, and she's sitting right here. So hopefully you can connect during this meeting. Do we have anybody else who aim to provide public comment? Yeah, well, and good for you. Thank you. And nobody else has registered?
No one else has registered.
Okay, so that concludes the public comment portion of our agenda. We'll move on to next item, which is approval of prior meeting minutes. We have minutes for the July 16th regular open meeting. Any discussion on the draft we have in front of us?
no discussion, I'll move to approve the prior meeting minutes.
Voice vote, if you agree, say aye.
Aye.
Aye. So the minutes for the July 16th regular open meeting have been approved. Next, we have a lengthy consent action agenda. There's 11 items on here. Is there anything that we should discuss on any of these items before we proceed? Seeing none, I will move to adopt the orders proposed for the consent action items. Mr. Cameron?
Commissioner Nyberg,
Yes.
Commissioner O'Connell,
Yes.
Commissioner Aguilera.
Yes.
The motion to approve the items on the consent action agenda passes unanimously, Mr. Chair.
Great, thank you. Okay, so this is a meeting that gets nerds like me excited. We've got 3 significant rule makings. A couple of them have been going on for a while. So we can do those, or if, because we have some folks here, I would assume you're here for both the interconnection rule and the Socorro electric case. Is that right? Okay, so then we'll just proceed with the order of the agenda as posted. So first up on that is 23119 UT. We'll begin with presentation from Robert Lundeen. As I was reflecting with Commissioner Aguilera before this meeting started, this one and the next one are rules that are as old as we are, rulemakings that are as old as we are as terms as commissioners. The 1.2.2 began somewhere in 2023, obviously, and then the interconnection rule for rural co-ops really is an outgrowth of the interconnection rule that concluded even before we got here. So both of these have been going on for a while. Just personal note for this one, 1.2.2, I've counted 3 babies have been born since we started this. Mr. Lundeen has 2 children, and Alejandro in the back has 1 more. So very much looking forward to discussion today, and hopefully we can get to a resolution.
Good morning, commissioners, and maybe today we'll have a 4th child in the form of this rule that's been going on for 3 years. Today I have prepared for you a final order and a final rule in 23119 UT, which is the Commission's rulemaking on its rules of procedure. The Commission's rules of procedure are a behemoth. They're about 40 pages. They're the most commonly cited rules and reference rules that we have, and they address all sorts of procedural topics before the Commission. Now, we've issued an OPER last year with a proposed rule. We received a ton of public comments, which has taken significant time and effort to parse through, but we're here today with a potential resolution on the table. I have 3 issues that in my mind are unresolved. 2 of them are easy. 1 of them is perhaps a little more challenging. So if you would like, we could get through the 2 easy ones real quick and then move on to what I expect to be the topic of discussion for today, which is tolling.
Well, can you give us your list of 3, and then we'll see if any commissioner wants to add to that list?
Yes, Chairman. They are the newspaper publication provision and the artificial intelligence.
And then tolling.
And tolling would be the 3rd.
Commissioners, did you have any issues you wanted to talk about in addition to those 3?
Yes, I have one issue to talk about, which is on the interventions and comment deadlines.
Okay. And then this is a long rule, been involved in every piece of it for 3 years. So I might have some concluding remarks, but I think in terms of the things we need to understand better and debate, that's a good list. So I would propose we proceed with Mr. Lundeen, if you could take them in that order: newspaper publication, AI, tolling, and then intervention deadlines.
Yes, sir.
Thank you.
So the newspaper publication provision in question is in section 24 of the proposed rule. This should be roughly page 23 of the Word file. And this is a section that was largely unchanged between the proposed rule and the existing rule. There are several examples of types of proper notice that may be provided for a public hearing. One of those is publication in a newspaper of general circulation. There were some comments in the record asking to strike that, given that newspaper publication is becoming increasingly outdated. It's time consuming and expensive as well. So striking that from the list would not preclude the ability for the commission to require notice by newspaper publication, but it would just remove it as an explicit item on the list. So it's marked for deletion, but I was under the impression that perhaps at least one commissioner wanted to keep it. So.
Yeah, I'll out myself as the one wanting to keep it, and mostly it's just the philosophy I've approached with this whole draft, and when we got to the end, is just reinforcement that hearing examiners are empowered to run these processes. And I'm also nostalgic. I learned to read by reading comics in the newspaper, so I'm unwilling to give up on the newspaper yet, even though everything you said is absolutely true. So I thought just leave it on the list, let hearing examiners decide whether it should be included in the notice or not. Also recognize, the 4 IOUs that come most frequently in front of us, the 3 electric utilities and New Mexico Gas Company. Each of them has a very unique service territory. And so, for example, I would think it'd be odd not to have Albuquerque Journal for PNM and New Mexico Gas Company, but maybe there isn't a newspaper of general circulation in SPS's territory right now. I don't know. You would know better than that, Commissioner. But so anyway, for me, it was leave it in there just to be something that you'll have to think about when you choose not to use the newspaper for notice. That was my whole thought process of leaving it in. It's not something that I feel is necessary to be in there for the rule to be complete.
The issue of publication is not a new one for governmental entities generally. There's been some discussions of removing that requirement in a lot of venues, and it's the media that keeps pushing back. In fact, there was some discussion years ago of having a state, official state place on the web that would contain all the legal notices. So anybody could check all the legal notices statewide at one place that'd be maintained by the state. That was always opposed by the Broadcasters Association, and it never got traction. So for those that live in Santa Fe and Albuquerque, you have a regularly delivered paper. For most of New Mexico, you don't. The Roswell Daily Record, I think, is published 3 times a week now. So it's no longer lives up to its name. The Eastern New Mexico News, Clovis Portales, I don't know what their publication schedule is, but the impact of newspapers has been diminished as we've seen the subscribers to newspapers continue to decline, particularly in the rural parts of the state. Most of the counties in the state don't even have a local newspaper anymore. So to me, I guess if it's discretionary, and I thought I heard Mr. Ledeen say that striking that paragraph does not preclude a requirement that it be published, but it would kind of highlight to the hearing examiner that probably for a lot of things that we deal with, particularly outside of P&M territory, there probably is no need to publish in a newspaper because there's limited, newspapers are going to be limited audience to begin with. So I'm ambivalent to the point that having something discretionary at the hearing examiner level is fine with me, and whether it's explicit or not, as long as they know that they can do it, it would be fine with me.
So for me, when I was thinking about this, I was thinking about more the logistics and the costs of circulating in a physical newspaper. It tends to take longer, and it also is not cheap, I think. From my understanding, in different situations, I've understood that it often costs thousands of dollars to do and takes several days. And so I was thinking about the value that is provided to customers and those who need notice and the cost. And I think ultimately, most people are probably not using a physical newspaper, or they probably would receive notice some other way. I could see situations where a physical newspaper would be appropriate, and I'm also open to including some discretion for hearing examiners when they believe notice in a physical newspaper is in the interest of customers and stakeholders and the utility. I think requiring it in every case is, for me, probably doesn't reach that level of added value compared to the cost.
So you hate newspapers?
I read my news on my phone, so
Yeah, no, I get that, and that's why I understand that it was listed here to be stricken. Again, for me, the first sentence is everything on that list, whether you do it electronic or in print, is at the discretion of the hearing examiner. So, I was just out of preserving the option of using a newspaper was why I wanted to leave it on. You hear the swing vote, sounds like Mr. Neighbor.
Swing vote. Rarely am I the swing vote. What if you just simply inserted the word publication or online publication on the website?
Yeah, because your point is item 2 is, item 1 is put it in the print version.
Yeah.
Item 2 is put it in the online version of the newspaper. Oh yeah, I'd be happy with that. So
Would that work, Robert?
Yes, sir.
Yeah, so basically what I'm hearing we're saying is that item 1, which is redlined in the draft we're looking at, leave that stricken. Then put online publication or print or online publication. That you said. On item.
Well, maybe we should start at online publication on the website or in print of the newspaper.
Yeah, thank you.
I'd be amenable to that.
All right. So next item was AI.
As Chairman, it's section 38 of the proposed rule. This is towards the very end on page 43 and 44 of the Word file. So
At the very end.
this is section
It's new.
38
I
on
think it's
artificial
38,
intelligence.
yeah.
It's new. So,
Are we good?
yes.
Okay, so the proposed rule had 4 subsections listed in this provision relating to AI. In this draft, you'll see the first 2 proposed for striking with reasons in the comments. That leaves C and D, which become the new A and B. I think there was a proposal also from one of the commissioners to strike C as well, which is just leaving the single final subsection paragraph in there.
Mr. Chair, for my 2 cents, every document that gets filed with us is subject to our rules. Whether it's a law clerk that hands a memo to a partner that signs off on the pleading, or whether it's AI generated, or whether it's somebody else, or maybe a non-lawyer drafting something that gets sent to the lawyer to get put in. Ultimately, the person that signs off on the pleading is responsible for the contents of that document. And if there are problems with the document, regardless of source, they ought to be held accountable for the issues that they've created. To me, artificial intelligence is just another resource that people can use, not unlike just a regular Google search. We didn't have a Google search provision prior to this, even though I'm sure lawyers were doing some Google searches. We didn't have a Westlaw search requirement because we held people responsible for their pleadings. But all of a sudden, AI becomes this mysterious thing when ultimately, in my mind, the person signing off on the pleading is responsible for its contents, regardless of where they get it from. And so I would say we really don't need to highlight AI. If we want to remind people they're responsible for the work product that they present to us, then put a reminder in. But to me, the source of the information is irrelevant, and the attorney or the person signing off on the pleadings can't simply just say, oops, my bad, I relied on this. No, they are responsible for the contents of the documents that they present to us, and they're responsible for the accuracy, they're responsible for the factual nature of it, and the whole 9 yards. And if they're providing things that are unsupported or misguided or frankly just made up, then they should be held accountable for that regardless of the source, in my opinion.
Yeah, it's just listening to that was reflecting on part of it is the arc of the 3 years that we've been working on this rule. When we started this 3 years ago, AI was something that wasn't very well understood, wasn't in use. We'd had interesting stories of hallucinations getting filed in cases and courts, and so we thought, we need to address it. Since that time, it's frankly improved in its ability to make you more productive to the point where I'd be surprised if you're not using it in some way, shape, or another. And so it's kind of become normal, and that's how it fits in the lane of what you just described. For me, then is do we want to call it out or not? At the time we started this rule, I think we would have been negligent if we didn't, because that was just how are you going to deal with AI was one of the big questions 3 years ago. And I think that's what's reflected in A and B. my proposal was, I think it's still worth it to just mention that AI exists, especially in the world where we're kind of expecting people are going to use it. For my 2 cents, it wasn't just we can delete C, but I was going to offer an edit on D. And the reason for that is just the way C reads right now. It's don't be a jerk. And then D is if you are a jerk, expect sanctions. So my edit would be we don't need to say don't be a jerk, or at least I hope we don't need to in rulemakings, but maybe we do. And then start off with what's left with just delete the first party's failure to conform, because that's the jerk part. Just start with failure to confirm accuracy, veracity, existence is sufficient grounds for sanctions. So just delete that first bit of it. But then, I mean, I hear you. Why is AI any different from anything else you do?
If you do that, I would propose that you retitle the section head and not have it just limited to AI. I think it's broader than AI, but it's really just a reminder that parties are responsible for the contents of the documents that they submit to us. And I would not just limit it to AI. It's in my mind, it's broader than AI. It's goes to the very heart of what they're submitting and what they're responsible for.
I think those are really good arguments about kind of where we started and where we are now with this, and I agree that it is applicable beyond just AI. And so I guess I would, and I am persuaded to just generalize it and change the title and make it about just the information that is presented to the commission. But I would ask our council, is that already reflected somewhere else in the rules such that we may not need this section at all?
Thank you for the question, Commissioner. I think there is some crossover with section 11 of the rule. This is the form of pleadings rule. This is about page 10 of the Word file. But section 11 regulates the contents of pleadings, and that includes requiring a signature of the proponent of the pleading, and the signature certifies that the signer has read the pleading and that to the best of the signer's knowledge, information, and belief, there are sufficient grounds to support it, and it's not interposed for delay, harassment, or other obstruction. So there is some crossover there. By signing a pleading, you're certifying that you're aware of the content, in essence.
Yeah, the only thing that seems to be lacking from 11 is the reminder that you're subject to sanctions, especially if you're found to have not checked your work and it's misleading. Right? But maybe we can just move that last bit from the AI section into section 11.
That sounds like a solution. You're providing the reminder in the area where people are looking for the rules as they come up with their pleadings. So
Yeah, and I also heard a suggestion, which I think is a good one, to start with failure to confirm, so deleting that first part of the sentence, and then toward the end of the sentence, it talks about how the information is coming, and so or otherwise it says or otherwise produced by AI is sufficient grounds for sanction. So I think it would need to say or otherwise presented, removing produced by AI or some other form to reflect that. It's broader than just artificial intelligence.
Just waiting to see if, are you following that, Mr. Lundin?
Yeah,
I agree with that
I'm
suggestion.
trying to interpret it without the AI part. Reading real quick.
'Cause I was going to suggest we just add that to the end of what Commissioner Aguilera suggested. Add that to the end of 1.2.211D, errors and defects.
Yeah, and on 11, you need a heading on paragraph E as well. All the others have headings. E does not. I need to do something.
Chairman, was the proposal to strike the last part of the sentence about AI and just make it general?
Yeah, I'll let Commissioner Aguilera repeat what he said, but yeah, it was take the edit to what's currently 1.2.238B, make it general, and then move it to the end of 1.2.211D. And if you can repeat the edit you suggested.
Yeah. So right now I'm looking at section 38. It would say something like failure to confirm the accuracy, veracity, or existence of statement of law or fact that was drafted, generated, or otherwise presented to the commission. You can play around with that. It could be presented in a filing, is sufficient grounds for sanctions. And that was just kind of what I heard about deleting the first part of the sentence and make it apply more broadly beyond AI. I think you could say that in different words also.
So I would have the party's failure to confirm the accuracy, veracity, or existence of a statement of law or fact presented to the commission as sufficient grounds for sanction.
Yeah, that would be fine with me. I'm also happy to, for others to revise it as it might be appropriate.
I think you may have to take a moment
Yeah.
to get the proper wording.
Yeah.
It's going to require more than that because it's not just their confirmation, but it's the substance.
Yeah, that's a good point.
That needs to be there. So I think it's going to take a little bit of work to redraft that slightly.
Commissioner, I hesitate to do a complete redraft of this paragraph here on the spot.
Yeah.
Yeah, no, and
No,
this is something that Mr. Lundin and I talked about before the meeting. Didn't quite know if there'd be any changes to the draft, if they'd be substantial. One of the things I thought we could do here is reach agreement on what it needs to say.
Yeah.
If it looks like there needs to be adjustments to the final order and the rule that are substantive, what we can do is reach agreement here, give it back to Mr. Lundin, and then he can make the edits and even put it on consent at the next meeting, because we will have had the discussion today, and all that does is allow commissioners opportunity to have read what they're voting on. So anyway, I didn't think we would necessarily get into that space, Mr. Lundin, but it feels like we're there with this AI, because that's also going to require, shouldn't be difficult, but some adjustments to the final order to explain. We thoroughly hashed out this issue and have decided it's broader than AI and made a change to section 11 instead. I think it's worth it for the final order to describe that too.
And you want to run some language by me, I'd be happy to look at it.
Yeah, I think it feels to me like we're in solid agreement among the three of us, and so just landing the fish on the shore is what needs to happen. Okay, so next is tolling.
Yes, Chairman. So the proposed rule was issued with an either-or option for commenters, each relating to what the commission will do with suspension periods that come from statute. There was an option A3, which was the filing of a stipulation could result in the abandonment or withdrawal of the original application for purposes of resetting time period. That has proposed to be stricken based on the overwhelming comments in the record. The second option was a procedure for tolling suspension periods. Now, the commission has kind of a long history of including tolling procedures in hearing examiner procedural orders, but it has never had a rule on it. So part of this rulemaking was testing this question, whether or not we want or need a rule for tolling. The status quo is we don't have a rule, like I said, and it's just been included here and there in procedural orders. It's not necessarily a boilerplate procedural order provision. In the last few years, the hearing examiners have not been including it, but it has been used in the commission's history quite extensively, which has resulted in some issues, interlocutory appeals, and whatnot. So the discussion today is whether or not the tolling procedure as drafted in the proposed rule should be maintained for the final rule. And if it's not, whether or not the status quo should be maintained or not. Thank you.
Do I understand the argument of the hearing examiners is that they would just like to have the discretion whether or not it should be told? And as I read the rule as in the document, that discretion is really removed if the parties agree then the matter can be told or is told. Am I not reading that correctly?
I think that's fairly correct. The procedure as drafted in the proposed rule gives the signatories to a stipulation an option to include it or not. But the issue with tolling, or one of the issues, is whether or not it's voluntary. So the rule was drafted to make it or allow it to be voluntary from the parties. Whereas in some cases in the past, the commission has imposed it unilaterally.
Well, it seems that I don't mind the parties suggesting that the issues be told, but I also like the idea of the hearing examiners or this commission making the final decision on the tolling, accepting it or not, but giving unilateral control to the parties over that issue. I'm not necessarily in favor of that.
And Commissioner, the way that the hearing examiners have imposed it in the past is also to make it an agreement of the signatories.
Yeah, for me, it's an interesting one, and as Mr. Lundin knows, fully explored both sides of the coin there. First of all, in this world where hearing examiners commission has the ability and authority to manage its own processes, and tolling's been used in the past. It is an option that exists. So the question for me is whether to include it in the rule with some guidance for how it will be used, or just leave it out of the rule and then it's at discretion of hearing examiner. And it's a tough one, right? Because first of all, it applies in cases that have statutory deadlines. Second of all, places where I'm more familiar where it's become an issue or been employed are rate cases, right? And so we want folks, policy commissions have been to encourage settlement. And so many times, there will be a settlement deadline and procedural order, and then parties will come back, oh, give us one more day. Oh, give us 2-3 more days. Oh, give us a week. And that time goes by and you don't get a settlement, right? And so, or you get a settlement, like there was one case where we had a settlement where it was only between the applicant and one party, and all of the contested issues remained even after the settlement. So in that case, we just didn't certify a settlement and went ahead and had a hearing on the application without settlement. So those are the kind of things where it comes up. I'll say there's lots in this rule that we've done, plus a lot of hard work by many people to make sure that on cases with statutory deadlines that we're using the whole suspension period valuably. It's not like there was an attitude expressed by some when it got here 3 years ago that, oh, rate case, well, first of all, let's just wait 30 days to suspend it. And then let's suspend it for the full 12 months because then that gives us the most time. And they're like, well, what are you doing with that time? Like, well, I'm going to work on other stuff and not really engage with this until 4 months have gone by, right? So that's not happening anymore. When cases come in, folks are jumping on them right away, and we're not suspending, say, rate cases for the full 12 months. We're suspending them for 9, and then if we get to a situation where we need the 12, we'll know why, and so we'll go ahead and extend it there. So we've done, and then another very powerful tool that hearing examiners are getting out of this, I think, is the scoping order. So it'll help with management of which issues are relevant, which ones aren't. Some things you can just decide, hey, this isn't for this case. We're going to move it to another case. So they've got that discretion already. That also, I think, doesn't eliminate, but relieves the pressure that existed before that made tolling so important. So we've worked really hard to try to avoid situation where tolling's even an issue. So that's the argument for getting it out of the rule. Argument for putting it in the rule is, even with all that work, don't know, something's going to happen, and we'll be up against statutory deadline again someday. So in that case, if the hearing examiners are going to toll, or if the commission's going to toll, we have a blueprint for how to do it. So again, I've argued with myself quite a bit over the last few weeks on this one, and where I'm at this morning is it's probably better to have a roadmap in the rule, acknowledging that someday it's going to happen.
Thank you for that explanation. I think, like with the artificial intelligence discussion that we just had, you did a nice job of explaining where we were when this was, because it's been a while.
Yeah.
Things have changed, and as you aptly explained, the circumstances right now are such that we haven't really needed to use this, and I do agree that it might come up at some point, even if we haven't used it recently. But where I kind of came in today on this issue is reacting to a couple of things. One of them is that with both suggestions that we had in here, parties were saying that they're not good for stipulations. And as I've mentioned before, I support settlement stipulations whenever possible because I think that they do a good job at achieving the public interest often, and they save resources, so that less time consuming. And I also understand that we and the hearing examiners need time to conduct a proper evaluation and make sure that whether it's a stipulation or the original application, that it's fair, just, and reasonable. And I think that the tolling provision is a tool that could be used, and it still exists. I came in here thinking that we could stay with the status quo, and so I was thinking that it perhaps would be better to not adopt it in the rule and leave it at that, but the hearing examiners or the commission can still have that tool in their back pocket for whenever it is necessary. With one sort of verbal guidance that I would provide is I am sympathetic to concerns about the rate uncertainty that is created by not including a deadline to the tolling. And I know that the commission, as well, as far as I know, the commission has not unreasonably delayed action on a rate filing despite the lack of an end date in the tolling provision. But having an end date to that tolling provision provides certainty to the parties and the utility that the commission is not going to take too much time or an unreasonable amount of time. And so to kind of boil it down, I came into this meeting thinking that we could not include in the rule, leave the status quo where the hearing examiners still have this as a tool, but also provide guidance that when they use the tolling provision, include a reasonable end date.
Yeah, no, and frankly, that's another sub reason for why I thought it was worth it to have it in the rule is it also, I hope, motivates settling parties that, hey, there actually is a deadline we have to meet, right? Isn't that, they don't tend to disrespect the procedure order if they think discussions are going well. But so that's the front end, but the back end, hey, this is not an infinite well of time that's available to you. But whether we put it in the rule or in somehow in the instructions to hearing examiners, that would be something I would think a hearing examiner should provide as instructions for when you do come in with a tolling agreement. It has to be time bound. Something that isn't time bound just frankly acceptable. But again, my thought was give hearing examiners the discretion they need to do their job, just because I can't, I heard that in what you said too, is it's going to vary case by case what's a reasonable amount of time for tolling. There isn't like a magic amount. So at best we would say, hey, any tolling agreement has to be about. And I see no risk in adding that because I think that should happen whether it's in the rule or not. Would you be opposed to leaving tolling in under conversation we had? Can you work with Mr. Lundeen on just adding a couple words that says a tolling agreement has to be time limited?
I do think it's in here, isn't it?
Yeah, 120 days.
Yeah, 120 days.
Okay. So what you were going to say is if we took it out, we should include that instruction because it's a tool that exists.
Yeah, we should include that verbal guidance that there should be a reasonable end date to the tolling period. Yeah.
All right.
And the period's not to exceed 120 days, so it could be much.
Yeah.
All right. I just hallucinated what you said. Going back to our AI discussion. Okay, so Mr. Lundeen, sounds like we're commissioners are at after this discussion is leaving in the tolling provisions in section D. So you've got it highlighted in yellow here, but there was two options. The option that appeared later in the rule was the one that, what I'm hearing is there's consensus on just leaving tolling in.
Well, and just to be clear, I still think we should take it out and still use it, but
Yeah.
I understand kind of I understand right now that Commissioner Nybert supports including it.
Well, yeah, if you two are adamant to not include it, I totally agree with the world that it's a tool that exists and can be used. So I just want to see if we can get to consensus on that.
As long as it's a tool, whether it's in the rule or not.
Yeah, I just think the transparency of it being in the rule might be a bit of a motivator. Is where I'm coming from on that. But the big message and takeaway is tolling is real and it can happen.
I think you have to help us more here.
We have halfway saying
I'm-
out, halfway saying in.
I'm good either way as long as it's a possibility, whether the detail is in the rule or not. Whether the details in the rule or not is somewhat irrelevant. I do want the ability to give the discretion to the hearing examiners anyway. I was concerned that this was a one-way street and not discretionary. You know, the procedures that are set forth looks to me like it takes a lot of time because it has to get certified, it has to come up to the commission and all that. If the tolling can be done without all those procedures involved, I wouldn't mind that, but I agree. Tolling to allow parties to reach consensus makes sense. And as Commissioner Aguilera stated, we ought to encourage that, not discourage.
And I think that was part of the concern of why, I mean, frankly, tolling was one of the biggest reasons this rulemaking got launched. And it was originally posed as a one-way street, or at least parties felt like that's what was happening to them, because it would come in after settlement got reached. Like, I'm not going to even look at your settlement unless you agree to tolling. So it was a take it or leave it proposition. So putting it in the rule, I think, makes it so folks at least understand how and why it'll get deployed, and makes it more fair than leaving it to heads I win, tails you lose formulation.
Could you do it in one sentence and just say simply the hearing examiners and the commission have the discretion to pull the proceeding?
Yeah, the worry there is then we're back to the fear that generated this in the first place was that if that makes it a one-way street. Here's a looming threat that we can do to your case. This one, it's like, hey, if you want to enter a settlement and you're going to use some of the statutory window to make that settlement happen, we want you to be able to do that. Just understand that's going to require a new deadline.
But is there another concern that a party could say, I'm not going to agree to the stipulation unless you put my things in, and I won't agree to the tolling unless
This
you agree to this?
I see this as applying to not just unanimous stipulation. You can have stipulations where a critical mass of parties have agreed, and in that case, you've got contested stipulation.
Yeah, and it references the signatories.
But it says all other signatories.
Yeah. If you didn't sign, you're not. You can contest it.
So you don't read that as all parties.
No. And I think there's value even in contested stipulation because it helps provide contrast. First of all, stipulation is something that arguably is a reasonable result because you've got a mass of the parties saying this is a reasonable result. And then it also gives, as commissioner and hearing examiners, point of emphasis for compare and contrast because you've got other folks saying, well, that I didn't sign that because of these reasons. So it kind of helps narrow or put a focus on which issues are critical for the public interest question. So I want to encourage settlements even if you can't get a perfect unanimous.
Again, as long as it's a tool, I don't care whether it's in the rules, so.
I think in that case, for transparency, we'll include it.
Okay. So we're back to the status quo,
Commissioners, if we're moving towards including it, then in that case, there was another concern raised by comments. It's paragraph 2B, and I included a simple red line edit to hopefully improve that paragraph, but this is the one that most commenters flagged as problematic. And the provision of tolling that could be described as potentially like coercive, in that, if you don't agree to toll, then your stipulation might not be considered. So this is the one where I think needs additional work, either striking it in full, going forward with the red line that I have here, or even reimagining a new way to do it. So.
Yeah, I appreciate the red line you gave because it just, to me, is a statement of reality. If you do a settlement and you've used up the entire statutory window and don't include tolling, then we're left with the coin flip option of law says we have to decide in this period of time, don't have time to decide, confused mind says no. So you should expect if you don't give us an opportunity and you don't give us ability to do our job, the risk of you getting a no is higher. So that's how I read. I agree. We need to include the red line you have proposed, but that's why
In B or 3
in B
2B.
2B it's in B
without prejudice.
So anyway, it was just a statement of reality that I left it in, and rather than it's the opposite of not telling people not to. Reminder: if you do not include that, you're taking on a risk you're trying to avoid by reaching a settlement in the first place.
Can the hearing examiner not toll the matter of their own accord?
No, Commissioner.
That's not a possibility.
So, Commissioner, the issue with doing it unilaterally from the Commission's perspective is that the public utility has some rights at play where, the Public Utility Act provides a defined period for the Commission to make decisions on rate cases. And I think the public utility has a right to a decision within that period, or else it's whatever application or rate may go into effect by operation of law if the commission doesn't make a decision within that time period. So for tolling to be a permissible procedure, I believe it would need at least the public utilities consent. So that's why this is drafted as a putting the onus on the signatories to include it, and then what happens thereafter.
Well, the situation I was thinking of, what happens if the utility wants it told? No other signatory agrees. Therefore, you can't have a stipulation with signatory parties. Therefore, the issue's not told because there's no provision for tolling. But there may be a reason for that matter to be in suspense for a period. You're telling me that the hearing examiner cannot allow that to occur even though the utility wants it?
That is correct. It would require the agreement of all the signatories to the stipulation.
Which means at least one other person.
Yes, sir. Now, what we've had happen in the past is, correspondence between the commission and the utility. The utility has agreed to waive its statutory or rule-based right to a decision in a certain time period. We've had that before, where it's just between the commission and the utility without stipulation being involved. But that would be a waiver, not a tolling issue.
While thinking is happening, I just wanted to clarify one thing about the statutory date passing and the application being approved by matter of law. I think it could depend on the type of application, because it could also be deemed denied by operation of law.
And yes, Commissioner, and perhaps approved or denied is maybe denied is more valid, but approved is probably not the best wording. It's, let's say, you have a rate case, the commission doesn't make a decision within the time period, then utility would potentially be allowed to implement those rates. So it's not necessarily approved. I may have misspoken.
Mr. Chair, I guess the more I read B, I'm inclined to agree with Mr. Ledeen that maybe deleting it is a proper course of action.
Yeah, I'm fine with deleting it because, like I say, it's just a statement of something.
I'm fine with deleting it as well.
Alrighty. Any other tolling questions, Mr. Lundeen?
Not from me, Chairman.
Okay. I think I'll turn it over to you, Commissioner Aguilera, for the intervention deadline.
Yes, thank you. And so I just wanted to elaborate, I think, some of the, let me find the section. It's 1228K, I believe. Yeah, general response deadline. I think there's another part to this story. So for some cases, we have clear comment or intervention deadlines. For others, we have intervention and comment deadlines established by the hearing examiners or in some procedural order by the commission. And for some, we don't have any at all. And occasionally we'll get a late intervention or a late comment. And so what this section does is it establishes a comment and intervention period we call it response here. I'm using the word comment, but it's really a response. And for anything that doesn't otherwise have one, so that we don't get those late requests. The other side of that is that I believe in my understanding was that we were also going to, as a commission, upload a notice of every filing. And, you know, hopefully E360 would be able to do that. So on the one hand, you have the commission saying, so issuing this once or twice a week. I was thinking twice a week, but this is what has been filed. It's Tuesday. This is what has been filed. Actually, I was thinking Mondays and Wednesdays. This is what has been filed since our last notice, right? And it includes the intervention deadline, the comment deadline, a link to the E360 case, and it's transparent to everybody who is interested what has been filed. Now that piece that I just explained about E360 or maybe its staff, I don't know if we ended up with the ability for E360 to do that, but that part is not stated in the rule. Only the other part about the response deadline. So anyway, I think it is for transparency, it is important for the commission to highlight what has been filed with us, to give any potential interested party an opportunity to engage and participate in that proceeding. And yeah, so anyway, that's one thing that I wanted to talk about, because I don't think that other part was necessarily clear to the stakeholders after reading some of the comments.
Okay, so you just wanted to make sure that was clear.
Yeah.
No edit to the draft. Okay, and appreciate your comments. So I've emptied most of my bucket in talking about the AI and the tolling. There's just a couple other things for folks who've been paying attention to this rulemaking that I think were important. One is just the practice of accepting public comment. In way back, there used to be public comment was taken at hearings. And so before the day that would set aside for a hearing could begin, there would be public comment. That was good. I mean, public comment's important. It helps sharpen the focus, and it definitely generates new ways for me to think about or look at what I have to do. But it also then, if there was a lot of desire to provide public comment, made hearings unworkable. You just couldn't accept the public comment and do what needed to be done during the hearing. So the goal there was to move public comment out of the hearings. So then that creates, I think, an obligation for us to accept public comments at the open meetings. We've had some interesting exploration when we're setting the agenda for these open meetings that OMA doesn't require public comment, but this rule does. So that's why public comment's a feature on the agenda. I just wanted to make sure folks understood that. And then we've worked on this rule just to make it clear for a layperson who is desiring to give public comment to understand what public comment doesn't do. It's not evidence that we legally can rely on when we're making a decision. So I wanted to make it clear that why public comment's happening in these meetings. We also have special meetings that are devoted just to public comment when we've got cases that generate a lot of interest in public comment, and we'll continue doing that. And then the last thing that I just want to add is another nuance to that change we've made is we've been trying to accept public comment early in the process, right? So because it's not evidence, if we have a public comment hearing or you give public comment before parties have filed rebuttal testimony or their own direct testimony in the case, then they'll have heard it, hopefully, and they can think about whether that shapes their position or their advocacy at all. So, just pointing that out, because there was a little bit of a disconnect last public comment session. Is like, why are you making us do this now? Like, well, first of all, we're not making you give public comment. We're welcoming public comment. There's no obligation for you to provide it. Please do. Second is, we were doing it now because nobody had filed testimony in the case that was the subject of the public comment session. So just trying to get what commenters think is important said in the open before the process is to the point of we're making a decision at an open meeting and the evidentiary record's been closed for a couple of weeks, right? So at that moment, what you say isn't something I can rely on, and it's not going to go in the final order. If you want to impact or shape the case with evidence that will be weighed and considered, provide your comment early. And then hopefully, we have a lot of public interest interveners in our cases. Give them the opportunity to hear what matters to you. So, long speech for a very small section in this rule, but public comment was something that's different than what we used to do, say, 4 years ago. And, this rule hasn't been overhauled to the extent we're overhauling it today in a long time. So that was one of the big changes that was in there, and I thought was worthy of, and just as I was worthy to talk about intervention deadline, I thought it was worthy to talk about the changes you'll see in the public comment. Again, it's clarify why it's happening, when it's happening, and what it does. And then as a follow-up, you'll see on the agenda for the next meeting is decorum is one of the items that's in the draft rule. Again, in the world where hearing examiners have discretion to manage the process, decorum's been reduced quite a bit from what was in the draft rule. Don't take much from that, because instead we're going to be talking about is it policy or resolution addressing decorum from the commission. So I just through this process decided, first of all, decorum is important. Second of all, it's probably a better way to handle it is a resolution, which is I see as instructions from the commission to hearing examiners and parties in front of the case. So anyway, those are two things that received quite a bit. And then just personal aside, I was fascinated by the number of comments we received on how long a document has to be before you have to give a table of contents. But, that says more about the group that practice here than anything else. So anyway, those were my comments. Any other things that you'd like to point out or emphasize before we close out on this one?
I just want to say thank you to all of the stakeholders who weighed in on this, and to Mr. Lundin for his work. It has been a lot of work, and it's been a long time with this, and I'm glad that we are able to vote on this item. We're doing that today.
Well, yeah, I was going to propose a motion, but go ahead.
I was just going to say, Mr. Lundin's tired of hearing me about the word unsworn. We see it throughout. The word unsworn, in my mind, is not necessary, but he has beat me about the head and face. I would just simply state that the rules, it says we're accepting these things if it has an unsworn affirmation. If it has a jurat, meaning it was sworn to, I guess we're going to accept it, even though the wording in my mind says that doesn't comply with our rule. But he assures me we'll go ahead and accept it. I would take the word unsworn out in every instance because I don't think it's necessary, but he has beat me into submission.
Well, this is fascinating because I've been pushing him in the other direction, right? I mean, for me, just having worked at a utility, you'd be amazed at how important it is that somebody has to sign a document. There will be not it games. There will be I'm not the expert, he's the expert. So it's important that when people bring stuff to it, somebody owns it. So that was instead of going the direction you were going, it's like this better mean it has to have a signature on it, right? So, and he assures me it does, right? So,
Well, I hope that parties that you know, routinely put a jurat on documents to submit them, that they won't be in fear that we won't accept their pleading because it doesn't conform with the rule as stated. But anyway, he assures me that that's the case. And I hope it's not used as a club that somebody is not adhering to our rules by putting a jurat on it.
And Commissioner, if I may, just to make it clear that an unsworn affirmation does have a statement that it is made under penalty of perjury and that it's signed. What it doesn't have is a witness notary public notarizing.
yeah, so this meeting's been bad for newspapers and bad for notary public. But the world moves on, right? We don't use boogie whips anymore either, right? Okay, so I'll propose a motion, move to adopt the proposal brought to us from Office of General Counsel today with edits on the newspaper publishing, the AI section, the tolling section, and that the final versions of the final order and the rule will be voted on at the next open meeting.
I'll second that.
Before I go too far, Mr. Lundin, did that match your list?
Yes, Chairman, I have
Okay.
three edits. Any necessary corresponding changes to the final order, and we'll bring it back, hopefully for consent action at the next open meeting.
Yeah, I fully expect that's the case. And I also know Mac Lee's gotten very adept at pulling transcripts from open meetings. So there are receipts on our discussion today. Any other?
Just obviously the order will need to be reflected revised as well to reflect the changes. But, yeah.
Commissioner Nyberg,
Yes.
Commissioner O'Connell,
Yes.
Commissioner Aguilera.
Yes.
The motion to approve the order with the edits to come back for a final vote on the next agenda for the next meeting passes unanimously, Mr. Chair.
And thank you, Mr. Lundin, and congratulations. A lot of work. So next, I'd say let's take a very short bio break. And then I also think, you don't have to run away, Mr. Fisk. So we'll do the interconnection rule applicable to rural electric cooperatives after a 10-minute recess. And then we'll continue from there. I'm also anticipating, I don't want to shortchange these discussion items that are on the agenda. So I'm anticipating we'll take a lunch break today also. So I'd say it is 11:24. We'll come back at 11:35, pick up with the interconnection rule applicable to rural electric cooperatives. And then for those of you watching, there aren't any rules with as many pages as this one we just went. We're in recess for 10 minutes. Smoke them if you got them. regular action item number 2, which is case 258, which is adoption of interconnection rule applicable to rural electric cooperatives. And again, there was a large overhaul of the interconnection rule that frankly happened in the last few days of the elected commission, and then what we've been focused on is implementation of that rule. There was a recognition that rural electric co-ops are situated differently than the IOUs, so that spawned this rulemaking. And so anyway, that's the background. And take it away, Mr. Fisk.
Thank you, Mr. Chairman, Commissioners. Well, at the risk of repeating a little bit of what you just said, Mr. Chairman, this matter commenced with a petition by the rural electric cooperatives for a rulemaking proceeding to adopt a rule regarding interconnection of facilities with capacity up to 10 megawatts, a rule that would apply exclusively to rural co-ops. The Commission amended its interconnection rule, as you mentioned, Mr. Chairman, 17.9.568 NMAC. That was in effective 2022. And since that time, the Commission has granted variances to co-ops from certain portions of the interconnection rule. And this led to the co-ops filing their petition for rulemaking. The Commission commenced this rulemaking by holding a workshop and subsequently required staff of the Utility Commission of the Utility Division to meet and confer with the co-ops to draft a jointly proposed rule. They did that, and the Commission used that rule as the Commission's proposed rule when issuing a NOPR. After the NOPR was issued, the Commission received written comments from staff, the New Mexico Rural Electric Co-op Association, or NMRECA, the Renewable Energy Industries Association of New Mexico, or REIA-NM, NUVE Holding Company, I hope I'm pronouncing that right, there are 2 V's in it, the Vehicle Grid Integration Council, and Kit Carson Electric Co-op. During the public comment hearing, we received oral comments from staff and Columbus Electric Co-op. Among the issues raised in the comments was the express exclusion in the proposed rule of vehicle-to-grid functionality from the definition of distributed energy resource, or DER. Some commenters remarked that there should not be in addition, some commenters remarked that there should not be a separate interconnection rule for co-ops at all, because the proposed amendments would disfavor the interconnection of DER to co-op systems as opposed to vis-a-vis the investor-owned utility system. There are 2 proposed orders before you. The first order would largely adopt the proposed rule with 2 changes. One, it would remove the exclusion of vehicle-to-grid technology from the definition of DER, as requested by most of the commenters. And 2, it would add the following language suggested by REIA-NM, which is, quote, nothing in this rule shall preclude a utility from establishing reasonable operational requirements for DER interconnection, including limitations on export capability, et cetera, et cetera. This language would be added particularly in light of the detailed comments provided by Kit Carson regarding the specific technical challenges raised by the interconnection of vehicle-to-grid functionality. The second order is proposed by Commissioner Aguilera. The order is identical to the first order, except that it would add the cost-sharing provision that is in the general interconnection rule, as recommended by REIA-NM and NUVE. And it would also make the posting of interconnection queue information on co-op websites mandatory instead of merely permitted as in the proposed rule. And with that, I will take any questions.
Great, thank you. And similar to Mr. Lundin, this has been a long process, and before we get into it, thank you for your work on this, and the comments were robust and well received and well stated. So not just thank you to Mr. Lundin, but everybody who's participated in it. I guess, would you mind, Commissioner Aguilera, describing the change from the draft that we had?
Yeah, so one of them is the cost sharing provision for situations when more than one generator might want to share in the costs of the upgrades. And the rule that was proposed to us removed that provision. It was using as a basis the regular interconnection rule that we have. And some of the commenters were asking for the ability to enter into a cost sharing agreement among themselves. And I wasn't seeing a reason that was persuading me to not allow that explicitly as an option. So based on those comments, I propose including the cost sharing provision so that the interconnecting generators may have the option to share the costs of the upgrades. And the next one, I just lost my train of thought. Can you remind me what my other edit was?
From shall to must.
Oh yeah, the other one was about the posting of the information about the interconnection queue. I actually did not read the initial order as optional. I thought it was unclear as to whether it was optional or mandatory. And posting interconnection queue information is a common practice, and so I didn't see a reason not to require that, and so it was a change from may to must or shall, so that they would post the information for transparency, so that potential interconnecting customers will have information and be able to make the best decision as to whether they want to submit an interconnection request or not.
Thank you. Any questions, discussions on that? Personally, I appreciate your confirmation that I read that correctly. I was looking at the changes, and the cost sharing is an option. I agree that it's good to include the option in the rule, and I also agree that in general, transparency on interconnection data is a common practice, and it's valuable not just to a co-op, but to the members who are trying to make use of their own devices. So I saw those as positive changes, or the already solid foundation of the draft that Mr. Fisk had given us.
On the issue of may versus shall, I just simply state that in that paragraph D3, does the queue shall be publicly available on the utility's website, and Russell, I would strike the shall be and update it at least monthly, because you got the first shall, it'll apply to both.
Right. Yeah, and that's what I was saying. There's a may and a shall. So to me, it wasn't clear whether it was mandatory or not. But
yeah, so putting the shall at the beginning, you can delete the second shall because it would require both. They make it available on the website and update it at least monthly.
Got it. Thank you.
Okay. I mean, I don't think we should talk about this for an hour like we did the last one, just because we talked about the last one for an hour. But I don't want to shortchange the importance of this. It is important.
well, I'll just say for my part, co-ops are different. I think they geographically they tend to have longer lines. Their structure is different, governance structure and ownership structure, and they don't have usually as many resources as the investor-owned utilities, And I do think it is appropriate because they are not similarly situated to the investor-owned utilities to have rules that are different and apply to the cooperatives. And so, I appreciate the work that went into developing this rule, both from the co-ops and from staff. And, I'm happy to support it with those changes that I suggested.
And one question I have on both drafts, the issue of the vehicle, the grid issue, the DERs, it's the same in both, correct? It's deleted.
Yes, in both versions of the order, yes. The two orders are identical except for the addition of cost sharing and the changing of the Q to shall. Otherwise, the other things that are in the proposed rule, in the initial order are also in Commissioner Aguilero's order.
And can you talk a little bit about, we deleted it, was that a result of comments that we received?
Yes, Commissioner Nyberg, I believe it was every commenter except for staff said that there was a deletion of there was an express exclusion added in the proposed order that was in the proposed order, and NMRICA, so all the co-ops plus Kit Carson said, let's delete that because it should qualify as DER. Now, the way that but like I said, Kit Carson did raise a lot of issues concerning the special difficulties that can arise with vehicle to grid functionality, and so I thought that that language, which I read part of, that was suggested by REIA&M about having the ability to impose different interconnection standards, specific requirements for functionally different types of generation would help ameliorate that. Because all the co-ops, including Kit Carson, said don't exclude it. So, but Kit Carson raised some issues about what difficulties there might be.
So I understand it. Each co-op can deal with that issue on its own accord. They're not being forced to deal with the issue of vehicle to grid. If they don't want to do it, they don't have to do it. They don't have to allow their members to engage in that program.
Well, the idea is that they would be able to include in interconnection agreements provisions that make it possible. And if that makes it, very difficult for the vehicle to grid functionality, whoever is trying to interconnect, that might mean that it doesn't interconnect. But it would allow the co-ops to add into their agreements whatever they need to address those specific issues. So it wouldn't be an outright. It's not saying that you could do an outright ban. But if the co-op wants to include specific provisions that deal with those issues, and maybe more burdensome to the vehicle to grid, or maybe not, they can do that.
And the co-ops are comfortable with the final rule that is in the documents that are in front of us.
Well, this is where motions for rehearing can come in very handy, because I use the comments that I had. I interpret them as they are. It's from NMRICA, and Kit Carson said we agree with NMRICA. All the co-ops said we're okay with not excluding vehicle to grid. But Kit Carson raised a lot of issues about how vehicle to grid is special and raises special issues. So I thought I'll take what REIA&M has suggested. That seems a reasonable compromise. So this is a version that I have put together from the comments. So it may be that we'll get a motion for rehearing where someone says these things don't really work together. That's why I think a motion for rehearing process in a rulemaking can be very helpful, because we have to take the comments and put something together. And sometimes people will say, the way you put this together doesn't work.
So at least right now, the rural electric co-ops have some discretion and latitude to deal with the issue.
Yes.
Okay. Thank you.
Yeah, and that's why I felt okay with it, is it gives them latitude. Vehicle to grid is going to be a reality for some co-ops, probably more than others. So that's part of the problem with, can't write a rule for one co-op. So be permissive, right? So that's how I assessed the draft we got from Mr. Fisk. Okay, so are there any other items to discuss on this one? Not seeing any, I'll go ahead and move for adoption of the order and the rule that includes the cost sharing option and the clarification on the data posting requirement.
I second.
And that was with the two other words being stricken.
Yeah.
Yeah, with the extra shall will be stricken, and then I'm not sure you said two other words. What other?
Oh, those were later in that sentence.
So just one of the two
Shall,
shalls.
struck may, and then the shall be, I think, are the other.
There'll just be one shall in there.
One shall in the sentence.
Okay. Yes.
Was that like double negatives? Too many shalls and shall not.
No, it was just make it. A little
No,
clearer.
I agree. Okay, so we have a motion and a second. Vote, please.
Commissioner Nyberg,
Yes.
Commissioner O'Connell,
Yes.
Commissioner Aguilera.
Yes.
The motion to approve the order as amended passes unanimously, Mr. Chair.
Great, thank you. Okay, so I was predicting to folks that we would take a lunch break around 12:15. What we have now is motions for rehearing. So were you like reviewing your own next job here, Mr. On community solar? I'd say let's go ahead and get started with that. We'll see how it goes. Might be a little later than 12:15 for those of us who've put in lunch orders. So take it away, Mr. Fisk. Case number 24258.
Thank you, Mr. Chairman, Commissioners. So on July 2nd, the Commission issued its order adopting rule amendments, adopting many amendments to the Commission's Community Solar Rule 179573 NMAC. On August 3rd, the Commission received 4 motions for rehearing of the order from the Coalition for Community Solar Access, the Coalition of Sustainable Communities New Mexico, Grid Alternatives, and the Solar Energy Industries Association. They filed a joint motion, so I'll refer to them as joint movements. Renewable Energy Industries of New Mexico, REIANM, or REIANM. Somos Energy Solutions, along with SVOE LLC and Sunvest Solar. They refer to themselves as Somos Sunvest, so I will do the same. And Solstice Power Technologies filed a motion as well. The proposed order would partially grant the joint motion, partially grant REIANM's motion, and Solstice's motion, while denying Somos Sunvest's motion. Specifically, the order would adopt modifications suggested by the joint movements to clarify the operation of the developer cap and the project selection process. Would adopt modifications suggested by the joint movements to expressly include the term subcontractors among the New Mexico resident businesses that would allow subscriber organizations to receive additional points in the scoring process to the extent that such subcontractors provide engineering and/or construction services. In other words, it expressly includes subcontractors among resident businesses with whom a company might contract and receive extra points. The order would decline to adopt modifications suggested by REIANM to include scoring provisions concerning local, quote, local and quote, permanent resident NM businesses, New Mexico businesses, would decline to adopt modifications suggested by RIA NM and the joint movements to include additional points for experience, would decline to remove language that was included in the final order that would provide the program administrator with authority to withhold an award of capacity to projects that would interconnect to areas of the grid where there is insufficient load to absorb the additional generation, leading to a need to transmit the energy to another part of the utilities grid. The initial version of the proposed order that I provided you included the provision as it was included in the final order, whereas the revised version that I sent yesterday incorporated revisions proposed by Commissioner Aguilera that would limit that authority of the program administrator to instances in which the mismatch of load and additional generation would necessitate point-to-point transmission on a third-party system instead of transmission in general. The order would also adopt modifications suggested by the joint movements that would allow annual recertification of low-income subscribers to be accomplished by electronic methods instead of limiting the recertification to physical mailings. The order would also adopt modifications to the consolidated billing provisions. These are the modifications proposed by Solstice, not all of them, and supported by our RIA NM and the joint movements. The order would adopt the modifications that modify and remove certain provisions from the final order that are in conflict with other provisions in the final order, establishing a net bill crediting methodology for consolidated billing. The order would decline, however, to adopt modifications that would add specific deadlines for the implementation of consolidated billing by the utilities. And with that, I will take any questions.
Great, thank you, Mr. Fisk. Commissioner Aguilera, also, could you describe the edits you made to the draft, just to make sure I understand them?
Well, the initial ones on page 4, I asked for additions, so like summaries of what the rule said, just for context.
On the final order?
Yes.
Yeah.
So some of these are wording changes. I know for sure one of them to discuss is the transmission piece. And Mr. Fisk, if you help me identify any other substantive edits, I don't.
Your edits didn't really change anything else substantively. They added more discussion and sometimes, for instance, in the experience section, you added a sentence that noted that that the act does not require the commission to take experience into account.
Right. Yeah. Okay. So,
like
I think the one to discuss then is it starts on paragraph 41. And so there was a I'm looking at the revised version, so this is what Jennifer passed around earlier.
Yeah. Yeah, the notes that Commissioner Eibert and I were comparing is we're talking about final order, paragraph 41, and then it flows through on the rule in G4.
Yeah, so final order, paragraph 41, the revised version is where I'm at. It might. So, but just to discuss the issue, this is one where there was a protest against The inclusion of the program administrator's ability to decline to award capacity. And now I'm starting to read the actual provision to a project that will interconnect to a portion of the distribution grid at which there is insufficient load to offset the additional generation to be provided by the project and which will require transmission service to a separate portion of the utility's distribution grid. And several of the comments expressed concern that the wording here is vague because it's referencing transmission, and that in addition, that the program administrator should not have the ability to do this, explaining that the customer or developer, bidder, sponsor here might already have an interconnection agreement, and it would not be fair in their view to have the program administrator decline to award them capacity after they've already offered the interconnection agreement. PNM came in and explained that that is not necessarily the case, that they can have that information about whether they need additional transmission service before the interconnection agreement. That's the context. The edit that I was making would be to, I agree that saying transmission service is very vague. And so what the impetus of the provision here, I understand it to be the CSOL case that we are all very familiar with. And so I added that will require additional point-to-point transmission service over a third-party system to add some clarity about the situation that would necessitate this, and to narrow it further, not just transmit, because transmission, I mean, like, are you talking backflows to the transmission system? I think the utility could potentially try to make an argument around that. And so I think that we need to make this as clear and as narrow as possible. So I don't know if you have it in front of you, but I added additional point-to-point transmission service over a third-party system.
Thank you.
Mr. Chair, this is the only change that I saw that I had an objection to, and we were trying, I thought we have discussed this and trying to come up with some language to give the program administrator the ability to deny a community solar project in areas where there was already community solar that was exceeding the demand on that local distribution system. And so it had nothing to do with third-party lines. It had everything to do with trying to make sure that community solar is located where the local distribution system can accept that energy, and not forcing community solar in areas where there's already sufficient community solar to meet the demands in those areas, but make them award contracts for community solar in areas where the demand can accept that energy. I thought the language that they came up with was meeting that point, but if we use the wrong terminology, or if the wrong terminology is there, but it had nothing to do with the third-party system. It had everything to do with, frankly, the same system. And so I think we may have talked about, the southwest part of the state is a very good solar area. And there may be a desire to put a lot of community solar in southwest New Mexico, but the demand is not sufficient to maybe absorb all that. Albuquerque, Santa Fe up here is where the demand is, at least on the P&M system. And the idea was to make the community solar more located in areas that are more match where the demand is. And so the point-to-point, additional point-to-point transmission is fine, but the words third-party system, that was never part of the discussion. That seesaw and that thing's been already determined and probably is pretty unique in the state. So if the wording needs to be revised, I don't mind it being revised, but the third-party system truly limits it and does not address the issue that I thought we discussed at some length several weeks ago. So that's my objection to this change.
Yeah, I saw everything that was in there as additional clarity. Part of it is two things. One, the law talks about when we were dealing with the solar bill credit, whether you can, how you treat transmission costs in solar bill credit. So this just makes it clear that we're talking about if it's a network resource, you're already paying network transmission. So it's like the white space around what these words say is what's really saying. If you're adding an incremental transmission cost, then that allows the administrator to take a harder look at the project. And to me, that's in line with exactly what we saw with CESOL. I don't think it's even too far away from what you're a proponent of. I like this change because whether you're talking about community solar or not, we're moving into a world where you should expect exports from distribution feeders. Might have nothing to do with solar that's causing that. And it might be something the utility actually wants because it'll help them manage their system better and hopefully reduce the needle peaks that drive all the generation capacity that we need on the site. So I thought this just provided clarity. It is the CESOL situation. I don't know how many others of those that can happen, but I didn't want to go too far to say there should never be exports from a distribution. And so as long as you're talking about network transmission, network system, I think we're okay. Was the way I read it. But I guess you got any stuff.
I mean, I agree with that. I don't have a response.
Did you have a proposed edit to the edit, or?
Well, I would delete over a third-party system.
I'm just trying to think through if you're having to buy point-to-point transmission, necessarily that's coming from a third party.
Mm-hmm.
And then you could delete the, if that's what it is, you could delete all the language. I don't, if it's unclear as it was originally written, then we need some clarity, but the idea was not to give the program administrator the ability to tell a community solar company, do not locate it here. There's sufficient community solar in that area that meets the existing demand. Put it someplace else where the demand is located. so we don't have all the community solar being built by Deming, New Mexico, or out at Animas. May be a great place for solar, but you, in my mind, you don't want that overloaded in one area of the state. You need that community solar to be where the demand is, and part of the arguments that you all have made is that it's to be a community deal where people can see what they're doing. Well, it's in southwest New Mexico or other parts of the state that are far removed from that demand. That goal is not going to be achieved. So this gives the program administrator the ability to say, don't put it here. We already have enough there. Put it someplace else.
Yeah, and I don't know that the program administrator should have that ability to say that. You know, if the concern is the words over a third party system, I mean, I think that's accurate. I think that if you delete those words, it doesn't change the meaning of it, because you're right. You know, they're either using additional point-to-point transmission service over a third-party system, or they're using network transmission service. So
Yeah, so I think where we'd gotten to was the objection was to the change. And
That one change.
yeah, and I understand the argument too. I also think there's other things in here that help with that balance. First of all, subscriber uptake. Second of all, if things do get too far out of whack, I think we're going to have to look at solar bill credit again. So there are things. This isn't the only place where balance happens. So anyway, I'm in favor of proceeding with the edits as described, because it does provide clarity around one example that I think goes beyond the way the law told us to look at it. And then this, there's no way to edit this without us continuing to struggle with community solar, I think.
I don't have any additional revisions. I think that was my substantive revision. The others, like I said, I think.
Yeah, I saw the others as just providing it useful clarity to what was already in the draft. And then Mr. Fisk said that also this morning. Feel like I read that correctly. So do you want to make a motion?
I will move to adopt the revised version of the order that we have been discussing. Order on motions for rehearing.
I'll second that.
Just to clarify, that's the revised 2 that I sent out yesterday.
Yes.
That's the one that includes the addition that I made regarding point-to-point transmission service.
Any further discussion? We're ready for a vote.
Commissioner Nyberg?
No.
Commissioner O'Connell?
Yes.
Commissioner Aguilera?
Yes.
The motion to approve the revised order passes on a vote of 2 yeses, 1 no.
Thank you.
Thank you, Mr. Chairman, Commissioners.
Okay, so now I propose we take our lunch break, which means we'll pick up at 1:15 with the case number 1800383. If people would prefer to not take a break right now and do that one case, I would say we could do that next one. But I definitely think we should take a break to make sure give the presentations the space they deserve.
Mr. Chair, you might want to ask the folks if they intend to leave after that case, because they might want to go home.
Yeah, that was what I was opening this up for. But, we're happy to stay with it if that's the last case you were here for. Okay.
Then I'd suggest we do 18-383 and then break for lunch.
Yeah, I don't know. Folks who've been around for a long time will remember a meeting where the commission ordered in hamburgers, and they were sitting up there eating hamburgers while everybody else was here starving. But we won't do that to you.
You know, a lobbyist would usually supply lunch, but that was in a different arena.
Smelly hamburgers.
Sometimes hamburgers, sometimes pizza.
Okay. Thank you, Ms. Stephans, and the floor is yours.
Sure, and I will keep it brief. So earlier this summer, the commission issued an order proposing modifications to Socorro Electric stipulation. Amongst the proposed modifications was requiring Socorro Electric to pay a portion of the penalties they have accrued and allowing Socorro Electric the discretion to determine how to pay that fine. And we asked for parties to give their positions on those modifications. In response, Socorro Electric filed a motion supported by all the parties that asked the commission to adjust the language in the commission's proposed modifications, which would see that which would restrict Socorro Electric from recovering penalties through rates or other surcharges from its members. And so the order before the commission is an order that confirms and accepts that adjustment in language and finding that it's consistent with the discretion that the commission had granted Socorro Electric in its original order proposing modifications, and asks for parties to submit the stipulation for final consideration.
Thank you. Any questions?
Mr. Chair, I'd move that we accept the order confirming Socorro Electric Cooperative's revision of the commission's order proposing modification to the stipulation in docket number 18-383-UT as presented.
I'll second that. Any further question, discussion?
I am going to abstain from voting on this order, and I'll explain why. I don't know if you'd like me to explain it now or after, but
Yeah, probably after you've actually done it. Roll call, please.
Commissioner Nybert,
Yes.
Commissioner O'Connell,
Yes.
Commissioner Aguilera.
abstain.
So the motion to approve the order in 18-383 as presented passes on a vote of 2 yeses, 1 abstention.
Yeah, so I think this is the first time I've ever abstained. It's kind of exciting. I'm just kidding. Yeah, so, I just want to explain quickly my vote, not get into the issues of the order, but I have concerns regarding the procedural path established in the prior order. The approach effectively created a back and forth negotiation dynamic between the parties and the commission. And in my view, this is not the proper regulatory role. So as a commissioner, I see my duty as to evaluate, approve or reject proposals that are presented before us, or where appropriate, conditionally accept a stipulation, for example, with clear parameters. So it's not my role to act as a negotiating party or participate in the bargaining directly with the parties. And because of the procedural posture this dynamic has created, I don't think it's appropriate for me to vote on this specific order. I do want to recognize that as a practical matter, the amended stipulation will be formally refiled with the commission. And once that amended stipulation is filed with the commission, then I will be prepared to evaluate it and cast my vote accordingly.
Thank you. I think that concludes the business on this item. So those of us who will be coming back will be here at 1:20.
120.
That was a good idea to have that.
Yeah, I didn't think it was going to take long. Okay, this is the New Mexico Public Regulation Commission reconvening after a lunch recess. For the rest of the meeting, we've got a couple of presentations from folks who work at the commission, and then communications with chief of staff and communications with commissioners. I wanted to make sure we gave these presentations our full attention, which you would not have received if I had not eaten lunch. So you have no hangry me. But
Thank you, Chair. Thank you, Commissioners. Good afternoon. Claire and I were asked to look at Rule 569 for projects over 10 megawatts, specifically whether the Commission should consider updating the rule. And for context, Rule 569 hasn't been updated since 2008. So rather than beginning with the assumption that it needed to be modernized, we want to first understand whether it's actually necessary to modernize it and what problems, if any, stakeholders are experiencing. As part of that work, we spoke with the IOUs, PNM, SPS, and EPE, as well as Sky Stanfield with the Interstate Renewable Energy Council. We also spoke with representatives from ESIG and Elevate Energy through the DOE's Interconnection Innovation Exchange. We asked everyone essentially the same threshold questions. Where do these larger projects actually interconnect today? Is Rule 569 being used? What interconnection problems are utilities and developers actually seeing? And what belongs in commission rule versus the utility tariff, the technical manual, or the FERC process? Now I'll pass it off to Claire to get more into detail about that process.
Great, thank you. Good afternoon. As Mackley mentioned, we spoke with several stakeholders to evaluate these questions surrounding Rule 569. In our discussions with all three of the IOUs, we were informed that the utilities had little to no interaction with Rule 569. PNM in particular cited limitations on their distribution feeders, meaning that their distribution feeders typically cannot accommodate interconnecting generating facilities much larger than 10 megawatts. Therefore, Rule 569 is often not applicable. SPS and EPE also noted that generating facilities above 10 megawatts tend to be too large to interconnect to their distribution systems. And then, in addition to our conversations with the utilities, we spoke with Sky Stanfield, as Mackley mentioned, at IREC, who was heavily involved in updating Rule 568 a few years ago. She suggested maintaining coverage of the distribution system interconnections above 10 megawatts. Although it infrequently applies, there may be circumstances in which it does, and we don't want to create a jurisdictional gap. She also recommended potentially collapsing Rule 569 into Rule 568, mentioning that New Mexico is the only state that separates its interconnection rules and that combining the two rules into one might be the most simple path forward. And again, like Mackley mentioned, we took advantage of the DOE's Interconnection Innovation Exchange Initiative. So we had office hours with Energy Systems Integration Group and Elevate Energy Consulting. It was very helpful, so I definitely recommend taking advantage of this resource if you're interested. They had similar input to IREC. They suggested that we maintain standards for distribution system interconnections over 10 megawatts. They also agreed it would make sense to consolidate Rule 568 and Rule 569 into a single rule. And upon discussion with all of the stakeholders, there are also a few additional topics that we determined do not need to be addressed through Rule 569. So we spoke with all the stakeholders about potentially touching on large loads within Rule 569. We wanted to get a sense of whether this would be an appropriate location to start forming guidelines and standards related to large load interconnections. However, based on our conversations with the stakeholders, the consensus is that Rule 569 is distinct from large load issues. Rule 569 specifically centers around generating facilities and their interconnection to utility distribution systems, and large loads go beyond this scope. And then we also spoke with the stakeholders about potentially changing interconnection queue processes and potentially incorporate a first ready, first serve approach. FERC currently uses this process at the transmission level. However, we found that no states currently use this approach for a distribution level interconnection rule. So therefore, it might be a complex undertaking without much precedent to go off of. And further, the interconnection queues at the distribution level in New Mexico do not appear to have significant problems. So overall, it doesn't seem like there's currently a real need to update the interconnection queue framework. And then lastly, another topic that we asked the stakeholders about was modifications made to interconnection applications that were already in the queue. There's a provision in Rule 568 that allows applicants to make non-material changes to their application while maintaining their queue position. We wanted to see if there should be changes or updates as it may apply to Rule 569. But overall, the IOU stated that they haven't seen any issues come up with non-material modifications. So it doesn't seem like there's a lot to investigate further there. So now I'll pass it back over to Mackley.
Thanks, Claire. So based on those conversations, Claire and I came up with 4 possible paths forward. Option 1, it's the minimal Rule 569 update. We keep 569 and we make narrow changes just to modernize it and we narrow the jurisdictional aspect. Option 2 is to consolidate Rule 569 into 568. So we'll eliminate the 10 megawatt division and we'll use 568 as a state jurisdictional interconnection framework, regardless of the project size. Option 3, we could do a major 569 rewrite, so a full overhaul. That means we'll create a full queue, study, co-location, cost sharing, and modification regime for projects over 10 megawatts. Or option 4, leave 569 alone. So our research and convos moved us away from options 3 and 4. We don't see any factual basis for doing a full queue upgrade, but leaving an 18-year-old rule untouched doesn't really help anybody. So the direction that we're leaning to is option 2. So rather than trying to build out Rule 569, we'll look to the commission to see where we can make some minimal and contained amendments to 568. Like I said, we'll remove the 10 megawatt ceiling and eliminate the need for a separate Rule 569. So the basic concept would be that smaller projects would continue through simplified or fast track review where eligible, while larger or more complicated projects will go directly to 568's study process. And also importantly, the projects governed by FERC's interconnection process would remain governed by FERC's interconnection process. So just to recap at this point, we started out by asking how to modernize Rule 569. The stakeholder outreach ultimately led us to a different question, which is whether New Mexico needs a separate Rule 569 at all or not. The IOUs reported very little practical use of 569. Larger projects either move into federal things like FERC or regional processes like SPP, and 568 already has the procedural framework necessary for state jurisdictional distribution interconnections. So for that reason, instead of creating a new queue framework, we think the cleaner path is to consider a narrow consolidation of the 2 rules while maintaining a clear boundary around FERC jurisdictional interconnections. So with that said, Claire and I are happy to answer any questions or discuss how the commission would like us to proceed.
Great. Thank you for that, and I really appreciate the outreach you did, highlighting that ESIG has office hours, so you can call them and ask questions. That's an amazing resource I was unaware of, but you utilized to good effect. So anyway, commissioners, did you have any questions for these fine young folks?
Same thing. Thank you for the research and collaboration and the memo that you provided us. What was the original basis for creating 2 separate interconnection procedures, one for above 10 megawatts, one for below?
Yeah, thank you for the question. So rules 568 and 569 were originally separated into 2 rules because of IEEE 1547 standards. So these standards currently apply to the most recently updated version of 568. But the version from 2003, which applied when both 568 and 569 were originally created in 2008, had a ceiling of 10 megawatts. So these standards couldn't be applied to any generating facility interconnections over 10 megawatts. So the commission separated the rules in recognition of the size limitation. Rule 568 required compliance with the IEEE 1540 standards, while 569 was separate because these standards were only for facilities below 10 megawatts. And then in 2018, these IEEE standards were updated and it removed this 10 megawatt ceiling. So now these standards can apply to a generating facility interconnection of any size. And so now can technically apply to any projects that fall under 569, but it hasn't been updated to accommodate that change yet.
Okay, so thank you for that. So it sounds like the original basis to separate the two procedures maybe no longer even exists.
Exactly.
And then my next question is, can you provide a couple of examples of projects that have interconnected using Rule 569?
Thank you for that, Commissioner. Thank you for that, Commissioners. That's a good question because we actually haven't been able to identify one. That doesn't mean it doesn't exist in the record, but during our conversations, what we do know, EP told us they haven't received any 569 requests in at least a decade. P&M said it has very little practical use on their end because, like Claire said, their projects generally move towards, the projects that I say generally move towards transmission. And SPS told us those projects of that size generally go to SPP and FERC. So we haven't been able to get the actual examples of projects. If you want, we could look into doing a bench request and asking the IOUs for that.
No, I don't think that's necessary. I was just trying to picture what what project would be using this rule. So it's not surprising to me that it's not used commonly, if at all. So thank you. I think your memo and presentation for me do support the second option that you've provided, which is to essentially eliminate from 568 a threshold. And it also seems like a targeted revision like that would not be too controversial or difficult to effectuate. So thank you.
I too appreciate the information you all provided, and I am certainly agree with you all that option 3 is a non-starter. If 569 is not been utilized and is not meeting any need, then folding it into or maybe even paring it down as we fold it into 568 makes sense. And I guess having an option in case something arises may make sense, but if it's really not being used, we should not have an extensive rule. And then deal with the real issues that we need to update. 568 makes sense to me. So I concur with your inclusions and the manner in which you want to continue to proceed, and you'd have my support.
Thank you, Commissioner.
Well, it sounds like you've got unanimous opinion. The reason I think it's worth it to fold 569 into 568 was exactly the question we were struggling with. Is hard to imagine a project that would use 569. Well, what if one of them shows up? And then we've got this rule hanging out there that they've got to use, but almost guarantee isn't going to apply because that IEEE standard it was tied to was from 2003, right? So, and then just education wise, very valuable that, there was that 10 megawatt threshold. I was the one that kept asking Arthur O'Donnell, well, you focus a lot on 568. How come you never bring up 569? And it was exactly what you discovered. It's just not very useful because that 10 megawatt pushes you onto the transmission system today, right? And then if you're on the transmission system, you are a FERC regulated interconnection. So the real boundary isn't how big the interconnection is, but who's got jurisdiction, right? So, and then it's even weird if you try to put in a kilovolt level because different utilities have different definitions of what is transmission and what isn't. So just making it clear, the dividing line is this not a FERC jurisdiction, it's ours, right, is a valuable cleanup. So my understanding, and that was what we had on the screen earlier, was a very, I wouldn't even say a first draft of a red line, but just kind of noodling around how much would we need to do to 568 to effectuate the change to 569, because I am not in favor of reopening 568. I mean, we're still in the process of implementing it. We got a few cases coming up in future meetings that are along those lines. Just had that discussion this morning with the co-ops. But if you can just change the boundaries in 568 so it applies to any New Mexico jurisdictional interconnection, that I'm very much in favor of doing, because that is kind of a backhanded thing we saw in some of the comments you received is, well, if you do open 568, we'd like to revisit this, that, and the other. Like, no, that's the only risk. But been assured, because this is just, we're eliminating 569, we can do a NOPR process on 568 that is very condensed compared to what we normally do. You guys did the legwork up front, so we don't need to do the investigation phase to decide what topics are relevant. We can just issue NOPR with the surgical changes to 568 that then allow us to also repeal 569. So those are the two steps. So anyway, that's my understanding. I'm getting head nodding from folks who probably hadn't graduated high school when this rule got written, right? So do you agree that what I described as a process is your understanding?
Yes, thank you, Chair. Definitely agree that option 2 is the way to go. Consolidate Rule 569 to 568. I don't know if Claire, if you want to add something.
No, I think that about sums it up, and I agree. Thank you so much.
Yeah, and I wanted to talk about kind of the jurisdictional split, because in reading that in your memo, it did highlight for me, hey, there's this, how do we word it in 568? And it's not clear. We just say interconnections. And I also want to be sure not to overcomplicate it, though, because there are nuances. And if we start to kind of get into those, then it can be difficult. I might just say, like, PRC jurisdictional and not try to define what that means, because I think that the split most of the time is going to be transmission distribution system, but there are nuances where I think there could be arguments that it's one or the other. And I don't necessarily think for purposes of this, that we need to open that can of worms.
Thank you, Commissioner. Agree completely. Yeah, the scoping language matters a lot. So we'll limit that Rule 568 just to the commission jurisdictional distribution interconnection. We'll make sure that's expressly put into the rule.
You mentioned Southwest Power Pool review process, and we know that the West is undergoing some transformations or whatever you want to call it at the present time. And as we go through this, we might just want to try to anticipate similar things happening with respect to EPE and PNM that would be a similar situation as what Southwestern Public Service faces with Southwest Power Pool.
Thank you, Commissioner. I think that makes complete sense, and we'll definitely take that into account.
I think that's why SPP always has a board meeting at Halloween, because it's frightening. Okay, so we put this on discussion and potential action, because if we landed on do nothing as the result, then no potential action needed. But it sounds like potential next steps would be if Claire and Mac Lee could work with Office of General Counsel on drafting a NOPR. Do we need a vote on that, or just voice vote? Or, I mean, it seems like we got consensus. If anybody objects, speak up. Okay, seeing no objection, could you please continue the good work you've done and take it the next step of NOPR to repeal 569 and then make 568 accept New Mexico jurisdictional interconnection?
Yes, Chair. Yes, Commissioners. Thank you.
Great. And again, great work, both of you. Where are you going, Mackley?
Actually, you can't go.
Okay, so the next item on the agenda is presentation from Mackley Carroll and Kathleen Tepe about inquiry into public utilities vegetation management plans and procedures. Floor is yours.
Thank you, Chair. Thank you, Commissioners. Good afternoon. Kathleen and I are here to provide an update to our May presentation on wildfire mitigation guidance following our prior presentation. After that presentation, we circulated the draft documents for informal feedback. We received written comments and held follow-up discussions with the IOUs and the co-ops. On the IOU side, that included SPS, EPE, PNM. On the co-op side, that included NMRECA, and this resulted in the memo before you. And the purpose of that memo is not to recommend a single outcome. It's intended to summarize the feedback we received and identify potential paths for the Commission's consideration. The central and high-level takeaway is that the utilities and co-ops are not objecting to wildfire mitigation planning or information sharing or continued engagement. Their concern is more focused on the form and the legal effect of the documents. Both the IUs and co-ops expressed discomfort on the documents being issued as a formal guidelines and policy because the concern there is that there's a thin line between guidance, regulatory overreach, and mandates. The stakeholders' concern is that even if the documents are framed as non-binding, they could later be treated as a standard of care used in litigation or function as a de facto rulemaking. One potential approach raised through the feedback is for the Commission to issue the material as a report instead, rather than a Commission policy or guidance. The idea is that the report could preserve the value of stakeholder process and identify useful wildfire mitigation practices while reducing the concern that the Commission is creating new obligations outside the rulemaking. As outlined in that memo, we've identified several key issues for the Commission's consideration that Kathleen will go into.
Thank you, Mackley, and apologies for not being there in person. So turning to stakeholder feedback we received, starting with the IOUs and then moving to the co-ops. SPS and EPE raised that both the Rule 560F document and the WMP guidance document should remain interpretive and flexible rather than becoming a de facto rulemaking. SPS supported the Commission's broader goals around wildfire safety, communication, and operational planning. However, they emphasized that the guidance should not impose obligations that are infeasible during emergencies, create conflicts with reliability requirements, or introduce additional security and liability risks. EP largely joined SPS's comments. One point that EPD did raise was that if the Commission ultimately wants to establish wildfire-related curtailment standards, it may be more transparent to amend Rule 560 directly rather than establish extensive guidance around the existing rule. The IOUs expressed support for continued discussion to address technical issues in particular. The most concrete technical concern involving the treatment of PEDS, EPSS, fast trip settings, and other enhanced protection settings. SPS's position is that these should be viewed as protective scheme settings rather than curtailment events. The settings may be used frequently, potentially even on a day-to-day basis, and do not themselves curtail service unless a fault occurs. Because of that, SPS recommended that any reporting requirements for enhanced protection settings be carefully defined, and rather than being reported on an event-by-event basis, be handled through annual reporting. EPE also raised concerns with the WMP guidance document. Specifically, EPE noted that the level of detail in the suggested elements could make the document appear to establish requirements rather than provide guidance. EPE also objected to language suggesting that the Commission could consider whether utilities incorporated hardening measures into new infrastructure during future prudence reviews. Their concern was that this could effectively link compliance with the guidance to future cost recovery. Overall, the feedback was not opposed to the Commission's wildfire mitigation goals. Instead, the primary concern was how these goals are translated into guidance and their potential legal ramifications. Moving on to the co-ops, the rural cooperatives raised many of the same broader concerns, but with an additional focus on the resources and legal authority available to smaller utilities. NMRECA's primary concern is that even if these documents are labeled as guidance, they could ultimately become viewed as a standard of care for rural electric cooperatives. NMRECA emphasized that rural co-ops may not have the funding, staffing, technology, or personnel needed to implement many of the recommended practices. They also noted that in some circumstances, recommendations may not be operationally safe or practical for rural systems. Vegetation management was another significant concern for them. The co-ops objected to language that could be interpreted as creating responsibility for vegetation outside of a utility right-of-way. So from their perspective, the guidance could potentially create duties beyond existing codes or standards while also increasing liability. The co-ops viewed PSPS as a complicated and believe each entity should be allowed to develop its own process. They questioned what benefit the guidance provides to co-ops if it creates liability risk without funding, safe harbor protection, or clear legal authority. They also expressed the concern that vegetation management language reads like overreach and that some broader issues may be better addressed through legislation, working group findings, or a longer-term process rather than immediate commission guidance. The co-ops also flagged terminology. They cautioned against words that are difficult to define or could later be used against them, such as robust, comprehensive, minimum, or high risk without definition. There are preferences for language that is tied to each utility's actual assets, legal authority, service territory, resources, and risk profile. Across both the IOUs and the co-ops, stakeholders emphasize flexibility, feasibility, reliability, legal authority, and liability. As Mackley mentioned in his introduction, despite our efforts to emphasize that the documents are non-binding and intended to allow for flexibility, stakeholders remain concerned that as currently drafted, the documents could be used as future standard of care or referenced in litigation. Turn it back over to Mackley.
Thank you for that breakdown, Kathleen. And while this agenda item was scheduled as a discussion item, we do have potential next steps in the form of 4 options. The first option would be to maintain the current guidance structure, but add stronger language clarifying that these documents are non-binding and don't create new enforceable obligations. The benefit of that approach is that it preserves the work that we've already done. It would allow the commission to continue providing direction and consistency around wildfire mitigation planning, PSPS planning, communication, and reporting in general without us starting over. It could also give utilities a clearer sense of what the commission actually wants and what we consider useful planning. The downside of that option is that it won't resolve the IOUs and co-ops concern. As Kathleen said, the IOU and co-ops have been clear that even with disclaimers, they are worried that guidance or policy could later be treated as standard of care or used in litigation. So this option preserves the commission direction, but it also carries the most risk of not addressing the IOU and co-ops, the issues that they've raised. Our second option would be to revise the documents into a wildfire mitigation working group report or just a staff report in general. The benefit of this approach is that it preserves, again, the substance of the work that we've done, and in addition, it lowers the legal and procedural concerns that the IOUs and co-ops have, and a report could summarize the commission's wildfire work to date, identify the stakeholder feedback, and outline common planning considerations while actually adopting those considerations as formal commission policy. This would allow the commission to continue building a record and preserve the value of the stakeholder process, again, while reducing their concern. An additional benefit of that is that Kathleen and I were actually working on this report, so we have about 80% of that already finished. The downside is that this report would carry less of a formal commission bite and direction. It may be useful as an informal document, but it won't create the same level of consistency or expectancy across that a utility guidance document could, in our opinion. So if the commission wants a more active regulatory posture, a report like this would feel too passive. The third option would be to continue stakeholder discussions or defer until there's some additional legislative action. The benefit of this approach is that it recognizes that some issues are actually bigger than the idea of a guidance document, talking about liability, vegetation management outside of right-of-ways, funding limitations, and so on. This option gives the commission more time and avoids locking us into a path until these larger questions are resolved. The obvious downside of that is that it could slow momentum. Like, we've already done significant work on wildfire mitigation and we've engaged the stakeholders in multiple rounds. So if the commission continues these kind of discussions about identifying the next step, it'll leave the work open-ended and we may lose that sense of urgency. The fourth and last option would be to initiate a formal rulemaking if the commission decides they want something binding requirements on wildfire mitigation and PSPS and reporting. The benefit of this approach is that it provides the clearest process for enforceable obligations. A rulemaking would give utilities, co-ops, consumer advocates, and other stakeholders the formal opportunity to comment. It would also create a more developed administrative record and reduce the concern that the commission is imposing mandates through an informal guidance. The downside of a rulemaking, obviously, of this magnitude is that it would take more time and resources, and would also likely expand the scope of the discussion. But at a high level, the question isn't whether wildfire mitigation is important. We all know that the stakeholders agree with us about that. The question is, what form does the commission want this work to continue at this stage? Is it a guidance document? Is it a report? Should we just continue the stakeholder process or formal rulemaking? Maybe all of the above. The choice is yours, and Kathleen and I are happy to answer questions and receive direction from the commission.
Great, thank you. My question, and maybe this is just a question for the universe and you don't have the answer, is it your sense that there's any momentum for legislation in the next session?
Thank you for that question, Chair. We've heard like the whisperings around, but we actually haven't seen anything yet. So until then, we just have to leave it up to the universe.
Yeah, because I mean, one seems like something that's worth doing just to harvest what you've learned. And then whether we go all the way to 4 seems like if legislation's actually imminent, it might be better to get legislation before we do the rulemaking. I didn't hear that, you know, other than the world's looking for New Mexico to have a formal process, that to me is the biggest thing I've heard is the issue here. But I didn't hear in your presentation that it was viewed as an ongoing problem that they're routinely filing the documents under the guidance that's previously been provided.
Thanks for that comment, Chair. It actually isn't a problem. We just figured that having it standardized and uniform would actually help us move further along as a state in terms of wildfire mitigation plans. But yeah, if the co-ops really don't see a problem with the way the PSPS documents, for instance, are at right now.
Okay. Any other questions?
Thank you, Mackley. And Kathleen, I appreciate the report. I would just tell you, I'm not in favor of option 1 or 4 at this time. I would be in favor of seeing a report, which would be option 2, with the addition of, I would not, in fact, I think it's important that the stakeholder discussions do continue. May not be as frequent as what you have, but I certainly would like to see that group continue, particularly if legislation gets introduced, and we need some mechanism to bounce those ideas off of and get substantial feedback so we know how to respond to questions we will get asked. So I think that process is helpful. So I would encourage us to move forward on option 2, and part of option 3 would be to continue the stakeholder process. And I'd be in favor of that. One thing in the report that I'd like to just point out, you had a whole section on Texas comparison. Nothing in that Texas comparison compared the laws that utilities would be facing in Texas versus New Mexico, and the limitations on liability that exists in Texas versus New Mexico. And that's one thing that's probably driving the response that we've seen from the IOUs anyway, who do have to deal on both sides of the line. There's additional, I'd say, protections, but there's additional issues in Texas that exist due to the laws and some of their requirements there that do not exist in New Mexico. So they would have more reservation about lawsuits being filed in New Mexico than they would in Texas. Just point that out.
Thank you for that comment, Commissioner. The reason I included that Texas comparison is because while Texas, they recently passed legislation requiring a wildfire plan. This is actually going to be their first year analyzing the plans. But the thing that I found interesting is that they actually, even though they had the legislation, they also included guidance documents for the utilities to do it, these pro forma materials. So I just figured like, oh, if they could do it, it's one of those things that we could do it. And something interesting too is because I've been in a lot of conversation with the Southwest commissions about wildfire mitigation. And I know it's not a race, but in terms of the West, it seems like we might be one of the last states to actually require wildfire mitigations, to legally require wildfire mitigations. And I figured that it's because, yes, the liability issue is a huge hurdle for us to get over, but everyone else has gotten over the liability issue. So, that's just some thoughts I wanted to share on that.
So my comments are very similar, maybe less strong on against the guidance, but I also think that the report would be helpful and that continued collaboration would be helpful. More important than having wildfire mitigation rules is doing wildfire mitigation. And I see the utilities doing that, taking it seriously, making investments, preparing for wildfires. It obviously is an issue. I mean, we're dealing with one, 30 miles from here, caused by lightning. But wildfires are a very real issue, and seeing the preparation that the utilities have been doing does make me feel like, well, maybe the rules are not really what we need to focus on right now. I do think that preserving the work that we've done the last 2 or 3 years, but maybe 2, in this docket is important. And so that's why at minimum, I would ask for the staff report, because even if there is legislation, that staff report could help inform the legislation what is important. And we don't have rules on wildfire mitigation, and it might seem like maybe we're behind. I don't know that I would agree with that, because again, I think the utilities have made the investments. The other thing that I would note is that in other Western states, there has been legislation passed requiring the regulatory commissions to do something about it. And we don't have that here yet. But utilities do have the plans. And so I would be in favor also of the report. I would, my recommendation here would be to also work with advocacy staff on that and issue whatever report staff thinks is appropriate. Obviously, I do think it'd be important for the commission to look at it, but I don't think that it would be something that we would rule on. And number 3, as Commissioner Nybert mentioned, that the continued discussion is critical, and also to provide any expertise and technical support that the legislature might need from like a factual basis. I think that would be important as well. On the guidance document, I do sort of see the concerns about it could be interpreted as a rule, but I also take that a little bit with a grain of salt. But I'd be fine not issuing a guidance document. And those are my thoughts. And lastly, thank you for the work that you have been doing on this case, and will hopefully continue to do.
Thank you, Commissioner.
Yeah, I mean, just to be clear, I also think step 2 is the thing that makes the most sense in this moment. So, and wholeheartedly agree with both commissioners that continuing an open dialogue is crucial. Especially because I still think we'd be better off with legislation than without it. So if the conversation helps create good legislation, that's in addition to the value that could be created by just starting to sketch things out.
Thank you, Chair. Kathleen, do you have any last words? Okay. Thank you, commissioners.
So I guess just before we close out that agenda item, do you feel empowered and have clear directions on what to do next?
Yes, I do, Chair. So just also based off what Commissioner Aguilera just said, so we will turn our report in, but we'll work with advocacy staff too to get their input as well. And, we'll share it with the commissioners before we actually do the report. And at the same time, we'll reconvene with the stakeholders and get the ball moving before the legislative session.
Great, thank you.
Thank you.
Okay, next item is communications with Chief of Staff, who
Yeah.
has graced us with her presence. You were threatening to leave earlier.
That's true. Good afternoon, commissioners. There's a lot happening at the agency, but you heard from our staff last meeting, so you're largely up to speed. Just a couple of things to highlight. The nominating committee meets again next week. They'll be discussing the questionnaire for candidates. Also, internally, we've talked a number of times in this meeting and elsewhere about the committees that the PRC formed several years ago after its strategic plan. We have 3 committees. For those of you who are not familiar with it, we have a professional development committee, a volunteer committee, and a wellness committee. Well, this past month, you have seen around both our Santa Fe and Albuquerque offices collection for school supplies for students in need in both Albuquerque and Santa Fe. And so I'm very proud to announce on behalf of that volunteer service committee that they will be taking 2 huge bins full of school supplies and backpacks to the schools for those kids in need. So thank you to all the PRC staff members who contributed to that donation, and good job, PRC Volunteer Service Committee. And then last but not least, it's that time of year again, even though it seems way far in the future, we are preparing the FY28 budget appropriation request, which is due September 1st, meaning that we will be meeting with you over the next couple of weeks to go over what that might look like in order to be prepared to present it to you on the, I think it's August 28th meeting, 27th meeting for a vote before that submission deadline. And that is the year in which our self-funding mechanism kicks in, FY28. So it'll be an interesting appropriation cycle for the PRC this year. With that, I stand for questions.
Yeah, thank you for that. And then, part of the discussion we just had on wildfire, discussion we had a week ago on water, might be worth it to start incorporating just kind of a legislative update. I don't know if that's something you want to handle, or we can put Jerry on the agenda or something like that. But I think at the moment now it's just what's going on. If there's things that commission wants to weigh in on or take a position, it's helpful to be proactive on that. So maybe there won't be anything in August, September, but I know there will be a day when suddenly we need to start talking about that. So that was the only thing on my list to ask for, is if we could start that ball rolling. Anything else? I appreciate it, and still amazed that we're a top place to work. So thank you. Okay, next on the agenda is communication with commissioners. I'll go ahead and start with that. Between now and next open meeting, I'm going to go to Vancouver, Washington for Markets Plus. Their members committee is meeting, and there's been a education process for the Markets Plus States Committee, MSC, just in anticipation of that market going live. And it was just kind of an interesting thing that came out of that education session is the governance design for Markets Plus was really sketched out in 2020, kind of codified in 2022, and then it's what we have now. If you work through that history and then think about how Western markets have evolved, maybe that design isn't great if, in terms of commissioners having a say in things that affect retail rates. So the idea is go in person to Vancouver, meet the folks, hear from them, explain to them how, especially experience at RSC, where commissioners have most direct impact on a few topics that affect retail rates. When you're at ISO and BOSER, it's kind of a more formalized conversation between state regulators and the board there. With Markets Plus, it's a little more of a remote relationship, maybe not as remote as you could look at it as being. So anyway, half of my going there will be to understand, but the other half is just to talk about big picture as these markets evolve out west. There's value in having regulators involved. If for no other reason, it helps build confidence in the market. It also might help the market folks avoid situations where they've got their state commissioners filings at FERC saying, gee, this market that my utility's in is making a bad choice. It'd be better to work stuff out before things get filed at FERC. So that's a message I'm going to carry to the meeting on the 25th, and then trying to be consistent with that message. So I'm also COSER in RAP, and same story there. Different version, but same idea is things like resource adequacy directly affect retail rates. So let's at least think about relationship between those markets and the state regulators. And then the big one that I think transcends all of the markets is, the action FERC took recently where they told CAISO and SPP, you tell us how you're going to manage seams. And for us in New Mexico, we might be as exposed to that as any other state, right? Because we've got two major utilities, both sides of the seam. Arizona, they're mostly the Markets Plus. Other states like Utah are mostly EDAM. So we might be living the contrast of seams as vividly as anybody else. We're also a little unique because we've been at SPP longer than most Western states. So we've got a little bit more experience with this. So all of those things are good. It's a message I'm trying to carry. I've been working with the EDAM group that is trying to develop a resource adequacy program there. And so that's the thread that unites all of that stuff is let's just take this moment to make sure we're building markets that operate and have, more confidence just because regulators have helped weighed in early before we're trying to figure things out. So that's my big update for what I'll be up to in the next 2 weeks. And then, as you guys are very well aware, conference season is in before Memorial Day and right after Labor Day. So things are ramping up. Going to go to the commissioner only Western Conference meeting at Park City in Utah. That is September 31st or August 31st, September 1st. There's a conference in Santa Fe, the LSI, which is interesting because it's a conference that has always existed for lawyers to come to Santa Fe to get CLEs. I'm afraid we've kind of undercut that conference with our own CLE conference, but it's still a good event. So I'll be speaking at that one on September 21st. And then still getting invites for things that aren't firm yet, but dance cards starting to fill up again. volunteer?
So want to add to the conversation that you were just having about seams. So an update is I was at that conference or workshop that Kaiso had. It was the first workshop of like a 4-part series on seams conversation, and it was very beneficial for me to be there. And you know, my message on that is that the seams are important. The reason that they're important is that they could create more costs for customers. And we've been doing in the West, we've been doing a lot of work to uh, bring up these regional markets for economic savings for the customers. And we don't want to erode the benefits that we've been reaching, you know, trying to get with bad seams agreements. And so that was kind of the message that I was sending there. Along those lines, I think it would be helpful for the Bosser and the MSC to have either a meeting that you know shows that both committees are taking this issue seriously. It could potentially be comments to the CAISO and SPP filing that is being required at FERC. And so I have a Bosser meeting tomorrow morning, and that's one of the things that I was going to raise there briefly for the Bosser members to think about. And sticking with the Bosser topic, the Bosser has been really busy with the regional organization for Western Energy, and there are briefing books that are going to be prepared for the board whenever that board is selected, and there's work to select the board itself. And so the Bosser has been very engaged in that, and that's some of what we'll talk about also tomorrow at the Bosser meeting. There's also going to be a Bosser training in Folsom, California, where Kaiso's headquarters are on the extended day ahead market. And so I'll be going to that. And now moving on to kind of speaking engagements, I'm going to be going to the Energy Bar Association Rocky Mountain Region Conference in Denver to be on a panel there. And then in October, I will be going to the Kaiso Stakeholder Symposium that they have every once in a while. I think it's every 2 years. And so I'll be on a panel there as well. So those are the things that I have going on.
Don't minimize it with just SPP.
Well, Mr. Chair, you know more about something I just got appointed to by President Rundell of NARUC and the N10 meeting that I guess I'll be going to some meetings dealing with work issues and possibly learning about some of the issues we deal with maybe at a higher level. So you probably know a lot more about what I just got myself into than I do. But anyway, I did get the appointment from President Rendell. It looks like the next couple weeks are going to be, I get to stay home for a while. I've been on the road quite a bit with SPP and NARUC. But beginning in September, it looks like, again, as you said, things are going to start moving quickly on the education front and getting us into other forums. And as I mentioned in the past, I'll be attending rate school in early October. have a couple speaking engagements, one in Albuquerque, and we'll be making a presentation there on transmission issues. The natural gas committee that Commissioner Fegan from South Dakota got me wrapped up in. We have a meeting in Washington D.C. coming up in about a month, and then have a number of important SPP meetings on the issue of cost allocation with respect to the high load transmission that's been proposed, and it looks like to me that what's going to come out of it, I don't know if the RSC will approve it, but what will come out of the subgroup that's been studying it is probably a revision to the cost allocation methodology that's going to allocate cost for these 765 kV lines, not just regionally as what would be happening if there's a 345 kV line, but it's going to go into the subregion. And so the first three 765 kV lines are scheduled all for the southern region. So they're wanting, if I read the tea leaves right, about 25% of those costs will be borne by the subregion, 75% by the entire region. But we'll pick up a bigger share of those costs. Fortunately, there's less miles in the south than there are in the other regions. So as that build out moves north, we may get maybe less cost with respect to the future build out. But the first whack of that is going to hit the south pretty hard. So we'll see what happens. It's scheduled for a vote in November, I believe, and I'll report what is ultimately decided by the Regional State Committee and the SPP board. But it looks like CARE is on course to recommend and modifying its current cost allocation formula. And that's one of the reasons why Ms. Malik and I have been attending all those meetings, is because it's big dollars that will get shifted around, and those 345 kV lines are expensive, but the 765 kV lines are really expensive. So that's my report. Thank you.
Well, congratulations on the N10. It's great that you'll get to do that. It really, my experience is it's really the FERC chair that drives the agenda and when you meet and what you talk about. But it's definitely a learning exercise, and you'll be there to represent WEC with Commissioner Rybarek from Washington, and just working with him would make it worth it me by itself. So, I mean, congratulations on that. And then all I gotta say is you wanted to be on SPP.
I'm glad I'm not on Markets Plus.
Well, I mean, what you described is a little frightening, right? Because that South region you're talking about, there's only two states, Texas and New Mexico.
Louisiana.
Oh, it picks up Louisiana. Okay. And then, all right, so that broadens it a bit, because I was just thinking about the southwestern leg, which is two states, Farmers Electric and SPS. So the votes are stacked against you. So maybe you can turn some of Commissioner Fegan's persuasive abilities around on her. I know if she came and asked you to do something, it's hard to say no, right? So,
well, we do have Commissioner David, who will be RSC president.
Yeah,
that's from Oklahoma.
Yeah. So anyway, that'll be interesting. And Ms. Malik, you had quite an experience being on the coaster there. So from chair to this, I think this chair might have been easy compared to this. So, is there anything else? Yeah, so I guess three of us are trying to get out and fight the good fight for cost allocation across the West. Seeing any further business, I think we're adjourned. I didn't see that.